Did you know that you can go to jail in Maryland for driving a vehicle that you know has no insurance? My name is Max Frizzalone, and I'm one of the attorneys here at FrizWoods. And in this video, I'm going to talk a little bit about Maryland's criminal traffic offense of knowingly driving an uninsured vehicle. In this video, I'm going to break down what the state needs to prove, what the potential penalties are, what some of the common defenses are, and then I'll talk about some of the adjacent offenses related to insurance and things like that. Let's jump right into it. What does the state need to prove in a knowingly driving uninsured vehicle case? Well, if you're watching this video, you may have been charged. So first and foremost, you can hear in the name, knowingly driving uninsured, that infers or tells you that the state is going to need to prove you knew there was no insurance on the vehicle. Typically, that's done through testimony of the officer and your admissions. So if you, the driver, were pulled over by Officer Bob usually just asks, is the car insured? If you say, no, I know there's no insurance on my car, then that might be evidence sufficient to prove you knew there was no insurance. As far as proving there was no insurance in the vehicle, the state typically does that through motor vehicle MVA records. So you understand the basics of the criminal charge, the elements. What are the potential penalties? For a first offense, the maximum penalty of knowingly driving an uninsured vehicle is 1 year in jail, a $1,000 fine, and 5 points on your license. If you've been convicted of this offense before, double it. 2 years in jail, $1,000 fine, 5 points on the license. So, incarcerable tickets are must appear tickets. If you've received one of these tickets, it says must appear. And the reason is that there's a possibility of incarceration. If you fail to appear for your court date on this type of case, you could get a warrant. All right, you now understand the elements, what's at stake. What are my defenses, Max? Well, defenses are usually specific to your case, but they're pretty common defenses in these types of offenses. First of all, were you driving your own car? If you were driving someone else's car, like say your Uncle Bill, and Uncle Bill said go take the Pontiac and get some milk, and you didn't know there was no insurance, then that's a good defense because the state will be unable to prove that you knew there was no insurance. Perhaps you're on body camera of the officer digging through the glove box saying it's got to be in here somewhere. Calling Uncle Bill. Where's the insurance, Uncle Bill? That might be a defense. Additionally, some of the other defenses might be related to the stop of the vehicle. Was the stop legal? In Maryland, as in most states, in order to stop a vehicle, an officer must have a legal justification under the Fourth Amendment. So we're talking about reasonable suspicion, probable cause. These are the standards the courts generally apply to motor vehicle stops, depending on the basis for the stop. Maryland typically does suspend the registration of vehicles that have an insurance lapse, meaning you need to have insurance on file with the MVA. And if you don't, chances are that your tags or your registration of your vehicle are going to be suspended. That might be the basis for stopping your vehicle as it is. So you now understand the offense elements, the penalty, some of the common defenses. What do I do if I've been charged with this criminal traffic offense? Well, first and foremost, speak to an attorney. An attorney is going to ask you some of the same questions you might have heard in this video. Did you have insurance on that car? Did you know it was uninsured? If neither of those things are true, you didn't know it was uninsured, there's no insurance on it, perhaps you might want to get insurance on your own vehicle, or you may already have insurance on your vehicle. If you had insurance on the vehicle you were stopped in, you would be not guilty of this offense. However, failure to have proof of it is a payable citation. So failure to have your insurance card on your phone or in the paper version is actually an $83 preset payable ticket. That might be all you're guilty of. There are also some other criminal offenses associated with having a fake insurance card that carries a maximum of 1 year. What you need to do if you've been charged with this offense is speak with an attorney. Some of these cases involve accidents. If you were driving an uninsured vehicle and you were in an accident, you might want to talk to an attorney about the possibility of being on the hook for some restitution, maybe related to the other person's deductibles. You might get sued for personal injuries. At the end of the day, the court does not want to, and the state usually does not want to, seek incarceration in cases involving uninsured drivers. What they want to know is that you are going to be an insured driver on the road. The reason is that insured drivers are safe drivers in case of an accident. Both parties might have their personal injuries or their property reimbursed through insurance rather than having to sue you and go to court for restitution and all of that. So, if you've got nothing else from this video, if you've been charged with knowingly driving an uninsured vehicle, the most important thing that you can do is speak with an attorney. If you are in Maryland, feel free to give our firm or any other law firm a call. I'm sure they'll be happy to give you legal advice about how best to handle this ticket. And make sure you go to court because if you fail to appear, again, this is a case you could get a warrant for over something silly. Good luck.